Hello and welcome to the Rogers Brief for February 18th, 2024. I'm Adam Rogers. Thank you for watching and thank you for listening. I'm going to be doing some stories from Nova Scotia as well as a couple of national stories this week. I'm going to start off with a discussion of the election interference inquiry that's taking place. It started a couple of weeks ago in Ottawa, and some of the national security concerns that have been raised and how those might be addressed by Justice Hogue, who's running the inquiry. And then I'm going to talk about a few Nova Scotia cases, two that have been appealed, two cases under appeal. One is Kayla Borden, an appeal of the Nova Scotia Police Board ruling rejecting her claim, and that's gone on to judicial review. So I'll talk about the result of that. That was in the news this week. Another one that was in the news, claim out of Port Hawkesbury's Fenwick MacIntosh appeal that was rejected by the Nova Scotia Court of Appeal. Talk about him trying to litigate against the victims of his sexual assault crimes, historic crimes. And another Nova Scotia case that's in the news this week was a claim involving a former candidate for the PC candidate and employee of the government, political employee, Nargis DeMolitor, and an individual that she accused of impersonating her and posting on her Twitter account against her wishes has now been charged criminally with impersonation, or personation is the criminal claim. Talk about that. And then finally, just an update on this situation, litigation out in Saskatchewan on school pronoun issue out there. So that there was a decision from Justice Megaw, who's been the judge handling this litigation between a group called You Are Pride and the Saskatchewan provincial government. So I'll finish off with that. A couple of programming updates or announcements. One is that there's not going to be a Sunday night show this week. Got word from Jordan Bonaparte that he's in Toronto and doesn't have the setup up there to manage the show with Paul Palango and I. They don't have good Wi-Fi in Toronto apparently, so there'll be no show this week, tonight, but next week we'll be back with the Sunday night show, the regular show. The other thing is keep an eye out tomorrow morning, Monday, the holiday Monday. I hope everybody, by the way, is enjoying the holiday weekend. Long weekend. They'll put out a little short video tomorrow morning, so keep an eye out for that as well. All right. So, the election interference inquiry. This, just in brief, is an inquiry into the efforts from government or non-governmental actors from Russia, China, and India, among others, to interfere with elections in Canada. Often it's nomination battles where, busloads of homogeneous looking individuals will show up and vote for one particular candidate. Allegations that that's being coordinated by foreign state actors and many different kinds of allegations. So the issue that's come up, so there's been 1 week of hearings in this, and this is the election interference inquiry that was originally going to be done under the guidance of former Governor General and Special Rapporteur David Johnston, now being done by Justice Marie-Josée Hogue. And the issue that's coming up is, how is this inquiry going to deal with top secret information? This is information gathered by CSIS, other intelligence sources. Well, originally, what has taken place here was that they had a sample of 13 documents that were given, saying, all right, CSIS, show us what you're going to do. And CSIS came back with documents that were heavily redacted and took like 200 hours of effort to deal with these 13 documents. And so that was determined to be too too many redactions and too slow of a process to be an overall, I guess, guide for the inquiry. So what they're going to do now is that Justice Hogue is going to be able to see all information, and she's going to be able to challenge any efforts or any submissions by CSIS or by the federal government to redact, to withhold any information from the public. And this is a challenge, right? Because part of what has to happen during an inquiry is to engender confidence in the process, but at the same time not reveal anything that's sensitive, secret information that might, harm our international relationships or ongoing investigations, whatever the case may be. So Justice Hogue is going to be able to see all the information and challenge any attempts to keep things secret. And their terms of reference allow her pretty wide latitude in that. Now, what's happened in other inquiries, and there's two in particular, the Mahar Arar inquiry and the Air India bombing inquiry. In both cases, there were similar challenges because there was national security information that the government was seeking to withhold, and the commissioner in each of those cases was able to see everything and challenge the initial determinations from the government. And so in both cases, there were then efforts from the government to apply to court and say, well, no, these cannot be disclosed. Well, each time that happens, there's a court application. It can take weeks, sometimes months to have something like that heard. And so it really slows down a process. This is an inquiry that's supposed to have an interim report in May and also a final report before the end of the year. So any such challenges that will delay the inquiry are not going to be well received. Now, so we're going to see. The other thing that Justice Hogue is able to do is if there's items where specific information she agrees is able to be kept from the public, then CSIS is to provide her with summary documents saying what's in those documents that are being withheld. Here's what they contain, and then Justice Hogue needs to sign off on the summary to say, yes, that is an accurate reflection of what's been withheld. So you can expect that what will be happening here are vigorous negotiations behind the scenes to, if information, okay, if you're not going to provide the specific information, then the summary that is a replacement for that secret information has to be, pretty thorough, a strong document that will, serve the same purpose as what the original information would have done. So we'll see. We'll keep an eye on that and see if there's going to be any challenges to Justice Hogue's determinations in that regard. But this is one of the benefits of having a judge rather than a special rapporteur, is that the judge has more tools at their disposal to order things and use the legislation that's at their disposal to make orders rather than recommendations that may be ignored. All right. So we'll watch for that and see if the government, on the government side, anytime they make a challenge to information, there's always going to be the question of whether they're doing it out of genuine concern that relationships, ongoing investigations will be harmed, or whether they're doing it just to avoid having the government look bad by the information being revealed. All right, so that's we'll keep an eye out for the election interference inquiry as that proceeds along. All right, I'm going to switch to three Nova Scotia cases before turning back to the Saskatchewan case. This, Kayla Borden appeal. Kayla Borden, young African Nova Scotian woman who was pulled over by the police in July of 2020 and arrested. So the circumstances were the Halifax Regional Police, one officer had been chasing a speeding car, suspected DUI, and was ordered to pull off the chase because it was going too fast. But put out an alert over a certain vehicle, a dark Pontiac with a I think, a light out or something. Well, another officer sees Miss Borden's car with the running lights on, looked like it might have matched the description, pulls over the car, decides on the way to the door that he's going to arrest her, and without having seen her, and then arrests her. Another officer comes along. She's detained for less than a minute. The other officer comes along, says, "Nope, that's not the driver. That doesn't match the description. All right, sorry, Miss Borden, off you go." Well, she alleged that was she was arrested and pulled over based on racial profiling by the Halifax Regional Police. Halifax Police Review Board ruled that was not the case, and made a lengthy decision on that basis, basically because the officer had decided in advance and that there was a reasonable reason why that they thought that was the car. It was in the same area. It matched some of the identifying markers of the vehicle itself. But there were 6 days of hearings to determine all of this. And in the Police Review Board decision, they said it was unfortunate that despite having heard the evidence to the contrary, Miss Borden maintained her position that the arrest was racially motivated. All right. And so this was appealed to the Supreme Court, and Justice Denise Boudreau issued a decision this week affirming the Police Review Board ruling. Now, it's not a hearing de novo. They don't do the hearing over again. She examines the Police Review Board decision, says, well, is it within their expertise? Did they make a decision? Is the decision reasonable? And all those things. It's not they don't get fresh evidence heard, and they don't do the hearing over again. It's an examination of the hearing. But Justice Boudreau did say that, in particular, that comment about it being unfortunate that, despite the strong, clear evidence that this was not the case, that Ms. Borden maintained the position that it was racially motivated. Justice Boudreau says there was nothing unreasonable in that comment from the Police Review Board. So, again, agreeing with that. I was curious about who or why this claim was being pursued, and I see the lawyer for Ms. Borden is Asaf Rashid, who's a lawyer called to the bar in 2021. So just 2.5 years into practice. He on his website has lots of photos. He does prison advocacy law. Human rights stuff. He's out, he's photos of him speaking at protests and such, trying to, I think, make a name in that field. And this, I think, was an effort to further that reputation, but I would say that was not a good case to take on if that was his goal. This one is a clear rebuke, I think I would say, from the court. And so hopefully that'll be the end of that. All right, so that was Kayla Borden's appeal. Certainly there is cases of racism in police forces. That wasn't one of them. All right. Fenwick MacIntosh, long-time criminal defendant, and now civil litigation defendant as well. Fenwick MacIntosh was convicted of multiple counts of sexual assault dating back, historical sexual assault cases out of Port Hawkesbury. There were some issues timing-wise with the criminal convictions, criminal cases. There were delays, and the delays were laid on the Crown and the court. And so ultimately, the Court of Appeal, Nova Scotia Court of Appeal, threw out the convictions, and that was affirmed by the Supreme Court of Canada. Nevertheless, the victims, the victims from Fenwick MacIntosh, and he was, like I say, he was convicted. The substantive criminal charges he was convicted of, but because he appealed on the basis that there was such delay in bringing the charges forward. So the victims sued him in civil court. The lawsuit was filed in December of 2019, and this was following an amendment to legislation. So normally the Limitations of Actions Act would say that you need to, well, it used to be 6 years, now it's 2 years. You have to make a claim within 2 years, but that legislation was changed to for sexual battery cases, so that there would be no limitation. You can sue, you can go back and sue, you know, whether it's historical or recent. MacIntosh filed his defense on his own, self-represented, in February of 2020. February of 2020, so just a couple of months after the original claim was filed. But then made a motion in January of 2022, when he was now represented by counsel, counsel from Cox Palmer, Michelle Kelly, who's a well-regarded, very busy litigator, no doubt a very expensive litigator. Now, amending a claim, taking this to the Court of Appeal, very expensive litigation. I'm wondering how Fenwick MacIntosh still has the means to continue funding these defenses and litigations, especially in this case. Or this case before the Court of Appeal was a long shot. So how does one have the money to fund, tens of thousands of dollars in legal fees for a long shot defense? I guess if it worked, it was going to be very helpful. But anyways, it wasn't going to shut down the litigation. What he was trying to do, what MacIntosh was trying to do, was amend his defense to countersue against the claimants for defamation, saying that when they alleged that he had committed these offenses, he spoke to the police, they spoke to the media, they spoke to politicians, and said MacIntosh did these things. Well, MacIntosh is saying, I didn't do those things, and you've defamed me by saying so. All right, well, here's how the time limitation issue works. There's no limitation on sexual battery claim. There is still a limitation on the defamation side of it. So there's a 2-year limit on when that claim can be made. And Justice Patrick Murray from Supreme Court of Nova Scotia gave a thorough decision on the timing issue to say, no, you cannot make that counterclaim. Might have been able to make it in your defense, but now it's, multiple years later. The alleged defamatory statements were made during the original criminal investigation, so prior to 2010, and many of them would have been made in the 1990s. So that claim is out. So the question is, even if it had been allowed, there still would have been, the claimants would still be making their civil sexual battery claim against MacIntosh. And then if his appeal had been allowed, he would have been able to counterclaim for defamation. So effectively, the judge is still going to have to determine whether the claims were true. And what do we know so far? We know that a criminal court has already said, yes, those were true. Those allegations really happened. And so it's difficult to see how MacIntosh felt that this effort to go to the Court of Appeal was going to be of much use to him. If it turned out that a civil court felt, and the civil standard is balance of probabilities, not the higher standard of a criminal court beyond a reasonable doubt, how the civil court was going to say, yes, we agree that none of this happened, and therefore their statements are defamatory, and have the victims end up paying MacIntosh. I mean, that was just an unrealistic expectation on his part. So I'm not sure how. I mean, the only explanation for having taken this step to the Court of Appeal is it buys MacIntosh some time. and if maybe he doesn't have much time left, who knows what his health is like, you know, he's trying to delay the judgment or delay the hearing of the civil claim and try to keep whatever money he may have left while he can still spend it. So anyway, some curious reasons for Fenwick MacIntosh to be making that claim, but Fenwick MacIntosh has been a curious individual. Okay, last Nova Scotia case I want to talk about is Nargis DeMolitor. Well, it's not really her claim this time. There's criminal charges against Samuel Shaji, Shaji, who Ms. DeMolitor said had been running her Twitter account. Now, this was not when she was a candidate for provincial office. She was running to be the PCMLA in one of the urban ridings. This was when she was employed by the province as an advisor to the Minister of Immigration. All right, so that was curious in the first place that she would have somebody running her Twitter account at that stage. But this 25-year-old Samuel Shaji was apparently doing so. But then she stopped having him do that, changed her password in like March or April. In September, I think it was after October 7th. So last fall, he apparently was able to access the Twitter account, must have figured out the password in her submission, and made a tweet saying that Israel must stop being the Nazis of the 21st century, and making a pro-Palestinian, anti-Israeli tweet out of it. So that got Ms. DeMolitor fired, and she has taken civil action against the Premier and the provincial government for having fired her. So this, I suspect the background of this situation is that Ms. DeMolitor has put pressure on the Halifax Regional Police, because this is an unusual charge, all right? So Samuel Shaji's been charged with personation, and that's under Section 403 of the Criminal Code, which means you impersonate somebody to either your advantage or their disadvantage, and that's a crime. This is a very unusual charge. You don't see this charge before the courts really ever. So that's the charge, and she's obviously been able to convince the police to take this on and you know, use their limited resources to charge Shaji with impersonation. Really going to be useful for her civil suit. Now, in the civil suit, there's an interesting wrinkle going on there, which is she filed the civil suit, but then filed documents to end. The province hadn't yet filed the defense, but DeMolitor has withdrawn her civil suit, but her lawyers have said that she's going to refile it. Unclear why. She wants to make some change to the suit, maybe include other people. When I talked about this story a few weeks ago, I wasn't sure who her lawyers were. It wasn't included in the story, but now we do know, because somebody from the firm of Levitt Chic in Toronto, employment lawyers in Toronto, prominent firm. This Howard Levitt is the Levitt, and he is the most recently renowned. Well, he writes some columns and stuff too in the papers, but he was representing Jordan Peterson in his failed effort to overturn the Board of Psychologists on Ontario order against him. So Howard Levitt, prominent employment lawyer. Maniza Sheik is the other lead partner. I never really knew who she was, but she's recently written a column in the Toronto Star advising the NHL to dump the 5 hockey players, the junior hockey players that have been charged out of London from 2018, saying, and the column really, anyway, I didn't think it was a very well written column, frankly, aside from whatever the point she was trying to make. Anyway, kind of inflammatory, trying to get attention out of the language of it. That's fine. Another prominent, people in the Conservative Party would certainly know the name, Catherine Marshall, wife of Hamish Marshall, who was campaign manager, and chief of staff for Andrew Scheer when he was leader. She's also a partner at the law firm. Anyway, so a prominent law firm, certainly know what they're doing, so can expect that they'll be vigorously pursuing this claim. Now with with the criminal charge, and if it's proven, certainly that helps DeMolitor. I'm not sure it wins her civil suit though, because you know, maybe if she presented this clear evidence to the government that it wasn't her that wrote the post, and they said, well, we don't care, it still looks bad, we're going to fire you, that could still go either way. Like if you're in a political position and something that's attached to you and is thus going to be attached to the government looks really bad, then there's case law that says you can still be fired for that reason. All right, we'll obviously keep an eye on that story as it unfolds. There's much more to come. Last thing I want to mention just quickly is this Saskatchewan school pronoun litigation, some unusual development there. All right, so the provincial government in Saskatchewan has introduced legislation that says if you are a student under the age of 16 and you want to change your pronouns, change your name at school, then your parents need to consent to that. And of course that's very controversial. It's been, now in Alberta, they're bringing in legislation. New Brunswick, they're doing something as well. Most provinces are not. Seems to be the better approach. But anyway, so what's happening in Saskatchewan is the government, I guess, trying to foreclose any challenge to this, has used the notwithstanding clause. So thinking, okay, this may be determined to be a violation of somebody's charter rights, but we're going to institute the notwithstanding clause and cut that discussion off. So you can, a government, provincial or federal, can institute the notwithstanding clause and say, despite this being potentially a charter violation, we're going to introduce legislation. Well, what does that mean for the litigation then? Because this group UR Pride is saying that this policy is against the charter and therefore should be struck down. Well, it's a moot point now because the government has used the notwithstanding clause, which covers, it has to be done every 5 years, but still, it's in place. But Justice McGaw says that no, even though it's a steep hill to climb, that UR Pride, the group that's advancing it, is still permitted to do so. Unusual. Most of the time, courts say, well, if it's a moot point and there's no reason to address the issue, then we're not going to, because they have lots of real cases they can decide. They don't need to deal with theoretical ones. In this case, Justice McGaw seems to think that it's important that the claim at least be advanced and the arguments be made, and so we'll see what happens with that. The actual decision itself has not been published. I'm just looking at media articles on this, so I'll be curious to see when it is released what the actual language that Justice McGaw uses for justifying the use of judicial resources for, what is not a hypothetical case. There's a real case going on, but it's a moot case in the sense that the notwithstanding clause really eliminates the need for an analysis of the charter compliance. Some would certainly say. Okay, well, those are the cases that I thought were interesting this week that I wanted to cover for you, and we'll come back, like I say, next week with another issue, the Rogers Brief, and another Sunday night show. We'll get back on that train next week as well. So in the meantime, thanks you everybody for listening. Thank you for watching, and we'll see you next time.